Hello, and welcome. Thank you, everybody, for taking the time and being with us for the LinkedIn Live. Joining us for the second LinkedIn Live session, actually, for the 2024. Today, we are going to be exploring the evolving world of staking, particularly focusing on the legal implications and recent international developments here. We'll delve into both the complexity of staking, technologically speaking, and compare the legal approach to it in different regulations or different jurisdictions, basically. We have an incredible lawyers, incredible people with us that can cover plenty of them. There's also going to be some talk about the recent legal breakthrough from Switzerland, possibly even the US, analyzing the regulatory stance on custodial and also the non-custodial staking services. Quickly about myself, I'm Anja Blaj. I'm a policy expert at the EUCI. We've been researching this topic for a while. It's been one of the hot topics I think a lot of people have actually been mentioning, especially when we asked what is going to be the focus in 2024 following up on MiCA. People have been saying MiCA number 2 or perhaps staking because it's not necessarily right now included in there. So today we definitely want to learn more about what the staking is all about. So I'll do a quick round of introduction of the speakers that we have. Feel free to add on top of that. I might not do justice to all of you. And then we have a set of questions prepared for the speakers. If you have any questions in the audience, feel free to actually type that into the comment section as well. We have the team ready to circulate those questions, and we can then bring them up to the speakers as well. Forgot to mention the new Swiss and Germany perspective on liquid staking. We'll definitely talk about that as well. So first we have Romina Bungert. You founded Bilaura Ventures, an advisory boutique for digital assets, DeFi, and on-chain structured products. Bilaura has been an independent advisor to Pool Maintenance Lab, which is definitely a leading nonprofit organization that supports research and education in the field of liquid staking. In this role, you were able to contribute to projects supporting the advancements and sharing of knowledge about liquid staking solution. We'll talk about that a bit later, like the Lido middleware. As part of your venture building activities, you've also managed several regulatory setups as COO as well as CFO for several DeFi protocols, projects, and blockchain-based applications in the field of tokenized securities and on-chain structured products. Among others, you've also contributed to Centrifuge, DOQ, Upvest, Elinvar, and the Beat Capital. Thank you so much, Romina, for taking the time. I know the schedules are pretty tight, but it's good to have you here today. Next we have, sorry? Oh yeah, thank you. Next we have Florian Prantl. You are a Swiss-trained and licensed attorney with a background in financial markets, regulation, and corporate law. You've co-founded and are a board member, if I'm not mistaken, of the DeFi Collective, where you oversee all legal and policy topics. The DeFi Collective, I think we've mentioned it on several occasions in the EUCI as well. It's an independent Swiss nonprofit organization tasked with furthering decentralization in financial services and supported by the likes of Polygon, Liquidity, Maverick, and DWeb. The DeFi Collective manages a growing seven-figure treasury to support DeFi protocols across 7 chains. This is fascinating. And it engages in other off-chain activities that support the cause. Apart from that, you've also acted as head of blockchain and regulatory at Lixer. I made a mistake, you are still acting as that. A tech law firm with around 35 people with offices both in Switzerland and Berlin. Lixer has been, I hope I'm pronouncing that correctly, correct me if I'm wrong, has been involved since the 2016 in both the legal setup, the expansion, and product offering of multiple blockchain projects from stablecoins over asset tokenization to FINMA inquiries regarding DeFi services. You regularly publish and lecture on crypto regulation topics and have also been involved in the process of new staking guidelines that have just recently been published by the Swiss regulator FINMA. Thank you so much for taking the time for being with us today. I hope there's going to be a couple of questions with regard to FINMA that we can address during this call.
Thanks for having me.
Absolutely. And then we have the third speaker with us. That's Chris Payne. You are a general counsel at Kiln, that is a leading enterprise-grade staking platform based in Paris and serving institutional consumer globally. Prior to this, you served as a corporate legal advisor at WorldCoin, the Tools for Humanity in Berlin and San Francisco, and were a general counsel and head of acquisition and capital markets at the Around Town Group in Luxembourg and Berlin. In addition, you've also worked in private practice for the US law firm and both London and Paris. So there is definitely a lot of jurisdiction perspectives, possibly connections that can tell us a bit more about the recent hearings, the recent insights of several legal cases. I'm happy to have you on the call as well. Thank you for joining.
Thanks very much. Pleasure to be here.
All right, so we'll start with the basics. Not really so much with the staking, but what we kind of want to hear is what brought you in the first place in crypto, and particularly what brought you into the focus of staking. What inspired you to actually look into that? We can start with the ladies. Romina, you want to go first?
Yeah, sure. So I've been in the space since 2017, and my background was capital markets, derivatives, and equities trading. And I also worked on launching a mutual fund that invested in tech and internet stocks. So I was quite aware on the technology infrastructure for securities trading and fund management already. And when I also supported on fintech company building, so not only the regulatory side, but especially like the technical operational side, it was very clear to me that the available technologies in the open global world or markets have not really been adopted and could have like a big potential. And that became particularly clear to me when I read about Ethereum and not only proof of stake in directly, but especially the part about the programmable money. And I think this plays, especially in Ethereum and proof of stake related concepts, this is really connected also to the consensus mechanism. And I think here with these technologies and methods, we have like great tools and ecosystems, not only for a global interconnected financial infrastructure, but also to create superior financial products, and especially structured products, than we know from the off-chain capital market. So that's what's fascinating me a lot about this topics.
Pretty cool. Chris, you want to go next? What brought you from WorldCoin to Kiln?
Yeah, sure. I'm happy to give a little background. I have I'd say a very traditional background in capital markets, corporate and M&A transactions, and I've always been personally interested in blockchain and cryptocurrency technology. And I think in the last couple of years, what's been most interesting to me is to see how that technology has begun to migrate outside of its, let's say, more anarchist bounds into the traditional worlds of finance. And so now you see on-chain bond issuances by large bond issuers. You see digital listing of DLT issued bonds. You see much discussion around tokenization of real world assets, and staking in particular, I think I was mainly dug deep into in connection with the current role in Kiln. And I think in the next 5, 6, 7, 10 years, you're going to see ever increasing amounts of integration between the traditional worlds of finance and the new on-chain worlds of finance. At some point, they won't be separate worlds of finance. And so being involved in seeing those two things coming together, I think, is the most exciting aspect of this job, and really having a chance to help shape that interaction and shape the, at times, rough melding of these two worlds together.
Yeah, that's always impressive to be on the intersection. And Florian, you are the one being there fighting or having a battle between the FINMA and possibly industry. Tell us more about your experience.
Sure. Yeah, I mean, so I think, initially I got into crypto also around 2017, 2018. I think in the beginning it was more out of personal interest for the market, to be honest, rather than through work. However, I did have a background in financial regulation, and at Lexer we started kind of getting involved in the ICO and other early projects back then. And, from that it just kind of rolled on, and we continued building the crypto practice and the crypto network in the coming years. And I mean, as for staking in particular, I think the topic became of interest from a Swiss point of view, kind of in the last year and a half, I would say. I mean, on the one hand, we always had a lot of requests of projects from abroad looking into the Swiss jurisdiction, but then on the other hand, it's the whole like FINMA topic. Our existing Swiss clients, they kind of got a bit concerned when FINMA issued some statements this summer or last summer, so summer 2023, hinting that staking might require a banking license or other type of licenses, and we're going to talk about that later on, I think. But this is kind of when it became a bit of more of a hot topic in Switzerland as well, and when we started, getting into discussions with FINMA and looking at it more deeply from a regulatory point of view.
That's amazing. Yeah, we'll definitely address that a bit later. Let's first maybe really shed some light onto the staking itself. What does it mean? Why do we have it? How did it even start? Maybe Chris, you can take us there and describe what's it all about.
Yeah, sure. I think fundamentally we were discussing this a little bit before we started the live stream. That the proof of stake is a method of securing and validating blockchains as a replacement for proof of work concepts that are used with Bitcoin, or as an entirely new concept, a new way of securing the network. And the rewards process that goes along with proof of stake is one designed to help motivate people, to give them an incentive to engage in the staking process. And in certain blockchains, for example, Ethereum, it also plays an inflationary role to counterbalance some of the deflationary aspects of the blockchain mechanics itself. But overall, I see proof of stake as essentially a way of validating and securing blockchains that are essential to their operation and essential to the ability of parties to rely upon the blockchain and the transactions that are being recorded through it.
Yeah. Maybe if I can add to that, so I second everything that Chris just said. I think it's here at some point important to distinguish that this is not a financial activity, but a technical activity, and it also needs to have this perspective when looking at how it should be regulated, that it can't be ruled with the same frameworks that we know from the financial services and capital markets.
That's a very important aspect to actually keep in mind. There is also this new concept called liquid staking. Anybody feels comfortable talking about that, how it differs from the traditional concept of staking?
Yeah, sure, I could do that, coming from my background and the work on Lido. So basically how I like to summarize what's happening in liquid staking, which basically means the user self-mints a liquid staking token when he deposits Ether that gets forwarded through a middleware. In the case for Lido, that is, for example, the case. And with that use of the middleware, basically the centralized staking service of one counterparty to another gets abstracted away. So you basically differentiate a bit the roles between the node operator that just runs the technical equipment or infrastructure and spins up the validator keys, for example, or the user that brings the stake for the validator deposits. And then you have a middleware that basically is extending a bit the Ethereum functionality, but usually those liquid staking technologies are also open source technologies. So what we can clearly see that here is no single or centralized counterparty providing a service. And this is for me one of the fundamental differences when looking at the more classical roles of native staking in a custodial or non-custodial form.
Would you say that there's also this difference of custody being vested with different parties in that sense?
Yes.
I think that, yeah, I mean, the custody question is a tricky question here because it depends a bit on how the liquid staking is being implemented and whether we're dealing here with really a custodial staking or a non-custodial staking arrangement through DeFi. I think when I think of liquid staking, what's important to me is to understand a bit the motivation of the parties here. If you're going to stake tokens, they're typically locked up for a period of time, i.e. they can't be used because they're locked into a validator somewhere. And parties say, okay, if we're going to stake large amounts of Ether, for example, 20% or 30% of Ether is currently staked, why should that capital just be dead? And liquid staking is a way to enable the use of the value of that Ether that's staked while still enabling it to fulfill the technical security function that staking is supposed to assist with.
So yeah, and for me that also means you don't not only have like the availability at all times of this new token that can also be traded away in secondary markets, but also that the token that you basically mint in relation to also what we just witnessed in Switzerland in the current discussions with who has the validator keys, or where are the funds locked up, how does the withdrawal queue looks like. Staking is basically, depending on how it is designed, but it can solve some of these points that FINMA also addressed and actually allow like a bit more flexible setup, and yeah, also to use the utility of the underlying Ether. And to participate in the staking rewards.
That's already bringing us closer to Switzerland. And Florian, could you perhaps share a bit more about whether FINMA already has a very good understanding of, for example, differentiating between these different types of staking mechanisms, and how do you even answer the questions that Romina has just brought up?
Yeah, absolutely. Yeah, I mean, I think when we start talking about the FINMA guidelines, I think it's important. I mean, there's on the one hand, there's kind of the story on how this whole came about now, but then kind of with regards to the content of the guidelines itself, they're really aimed at custodial staking. So FINMA differentiates first between like non-custodial and custodial staking. The guidelines really concern custodial staking, and then they make another differentiation between what they call direct staking and staking chains. So depending on how many institutes are involved in the kind of the staking process, but without jumping to conclusions, I think with regards to liquid staking, actually FINMA didn't take a position yet, and I think I mean from what we know from previous discussions with them, I think they wouldn't be comfortable right now taking a more public stance with regard to liquid staking. I think it's too early still, and I mean, as we've seen now in the discussion a little bit, there's just a lot of different forms of how liquid staking can be implemented in practice. I've seen and advised projects that are going for a non-custodial way of liquid staking, like Romina explained with regards to LIDA, for example, but then there's also an option to do it in a custodial way. And I think for me, when it comes to liquid staking, I usually think of it as kind of staking plus, so to speak. So there is, the regular staking activity that we described. So kind of users locking tokens to be able to validate transactions and then earn rewards. So this is, one side of the operation. And then the other side, of course, is kind of the minting of this receipt token that represents your stake. And these are two distinct elements of liquid staking that need to be distinguished when you talk about the legal implications, right? The first element is kind of with regards to custody, and then what we teased that a little bit. But then the second element, how do we treat that liquid staking token? Is this something that brings us closer towards kind of an investment activity or some kind of regulated instrument? I think that's a question that is also still left open by FINMA, and then unanswered. I have my personal opinion about it, and I think we have good arguments to say that it is not regulated activity, but it's there's not that amount of certainty around it yet.
Yeah, I think also they will have to make a case-by-case assessment, and looking at the speed of innovation in the market, that also makes sense. I think like from what FINMA has published, I think it was already quite a sophisticated way with a lot of technical distinguishments. So I really liked how granular their assessment was. And I saw also a few different aspects that apply to staking, but also to liquid staking players. And I think one was the central point that everyone was so anxious about was the nature of is staking, like where does the deposit definition, start or end, and its implications also to the capital ratios as a requirement, because that, like, if it's per se considered as a deposit, that would have been like very unfortunate. But then depending on what Florian and Chris also just shared about how institutions or staking providers are participating in this direct staking, and here I think there still is like a lot of operational challenges for the institutions when they had to handle like the fiduciary duties. And also when it comes to commingling and like where do you collect the ether, right? And when it comes to a bit more to the nature of payments, where we would then have like this bit higher standards on the fiduciary duties, which doesn't apply to all crypto assets per se, but more particular to the payment tokens and topics like this, when it comes to how granular does the wallet setup and the management of the incoming funds and the outgoing funds. I think this is still like a big challenge for the industry, but it probably also shows in what they recommended how it should be implemented so it doesn't fall under the banking license requirements. Was very helpful and provided clarity.
I need to reset the room and say that nothing we say here is going to be legal or financial advice, nor anything that we have so far said already. Just a quick caveat.
Yeah, I would say we've had a number of conversations with Swiss partners around how they're viewing this regulation, because we took a similar sort of view that the regulation was largely concerned with custodial staking. There's a few passing references to non-custodial staking, and what was interesting for us from a company perspective was try to understand what are the key concepts that FINMA seems to be focusing on here, either coming out of the DLT Act and things such as prudential regulation or segregation of customer assets, availability of assets in the case of bankruptcy, and then thinking how these could also apply to non-custodial staking, or what are we likely to see in that regard. And I think if I remember correctly, at the end of the guidance, there was a reference saying that if you engage in pooling, you still need a banking license, full stop, that pooling is still quite a contested area. I mean, Florian, I'd be interested to see what your thoughts are around this, but it seems like there's not a lot of clarity quite yet around pooling or non-custodial approach to staking in Switzerland.
Yeah, absolutely. I think I know which reference you're talking about, and we stumbled upon that as well.
Last paragraph, non-licensed.
Yeah, absolutely. Yeah, but I think, more in general, like it's fair to say that FINMA kind of regulates or tries to regulate staking the same way it regulates custody, which I think is a good way, basically saying, okay, like it's essentially custody, and on top of that, it's a technical service that we're not going to regulate. So that's basically what they're saying. And I think, I think the key point, as everyone was anxious about was, okay, are we able to offer custodial staking services without a banking license in Switzerland, right? Because, essentially we have large players in Switzerland. For example, Bitcoin Swister, I think they're one of the top 10 ETH stakers worldwide. They operate without a banking license. So, for them, like for the likes of them, it was really important to know, okay, is it legal or is it, fine from a regulatory point of view what we're doing? And I think there is kind of the main point was driven home there to say, okay, this is possible. But another thing to keep in mind, which is actually, which is not very largely understood, but it's important nonetheless, is that the main question that we're talking around here is actually not a regulatory question, but it's a civil law question. It's the question of whether an asset can be segregated in the event of bankruptcy from the bankruptcy estate or not. Because if it can be segregated, then you're not regulated as a bank, because the cost, the user assets are fine, right? There is no risk. And this is actually a civil law question that will ultimately need to be decided by the civil courts in Switzerland. And FINMA also makes reference to that, saying, okay, this is how we view it right now. But this is subject to potential change in case that the courts are going to, rule differently on that, which I don't think there's a large chance that this is going to happen. And actually, you know, we had a case recently in one of our previous customers in Zug. They operated, or they offered staking services, but they went bankrupt in the kind of the last bear market. And they were liquidated now, and they're the Zug authorities, not the financial market authorities, but the actual, you know, bankrupt the liquidators. They did actually manage to segregate and then take out the staked assets in the bankruptcy case, right? So from a you know, practical perspective, this is already happening. And there's always a bit the question of, okay, what's the law and what's happening in practice and what do we observe? But I think, you know, what we can say, it's already happening, and it works.
Yeah.
So yeah, I mean,
I think this is also exactly the point that I was referring to earlier. When it was also about the commingling, or as Chris also mentioned, the pooling. You know, what's happening on which wallet address, and here they really provided some clarity on what they expect to see in a custodial or non-custodial setup. First of all, where funds are collected, or can they be basically directly traced to each individual client? Or then also when it comes to the key management, because with, for example, Ethereum staking, you have two different keys. One would be the validator key or the signing key, and the other one, the withdrawal key. And if they can be made accessible to the clients for this bankruptcy relevant discussions and the fiduciary duties. And I think here, this is now really great because the institutions now know what is compliant and can move out of the gray zone.
I'm just going to go with a very rookie question. So the segregation of funds in that case, and surely it's going to be a case-by-case basis as far as I understand it, according to what you just explained, Florian, as well. If we have the funds segregated, does that mean that those funds that have been staked are not going into the whole mess from which all the creditors are going to be paid out? Does that mean that if I staked my funds, I'm actually better positioned?
Well, I think from Florian, do you want to speak to it? Sorry.
No, go ahead. I can always add.
We've looked at this question as well from the perspective of France, for instance, and other jurisdictions. I mean, from a consumer perspective, I think the idea is that if the underlying entity or its staking provider goes bankrupt, you shouldn't have your funds pulled in to settling the debts of creditors of the underlying entity, right? They should sit separately in the same way that securities, for instance, would sit separately, and they don't show up on the balance sheet of the entity itself. They're truly segregated. And I agree with Romina that the Swiss regulator gave some good guidance on what that would look like. You had segregated blockchain addresses per customer, these sorts of things. But it's also very interesting, Florian. I wasn't aware of a case that had actually tested this theory, right, to see if the bankruptcy trustee is able to tap into those funds, or if the courts or the trustee says, look, we agree, those are truly customer funds that shouldn't be used to settle debts of creditors, and we'll get them back to customers in a swift and timely manner. I mean, as swift and as timely as bankruptcy can be, but swift and timely, right? And those, I think, are very interesting questions for a lot of jurisdictions, not just in Switzerland.
Yeah, absolutely. And I think, there it's always, one question is what does the law say? And the other question is what can you do in practice? And the thing is, I mean, you can say, okay, as staked assets are segregated if they are allocated to an individual customer on an on-chain level, and if they are held readily available. Those are the requirements in Switzerland, the legal requirements. That's one side. But then the other side in practice is, what do you do if one of these service providers goes bankrupt and they didn't have kind of, well-kept books of, where the assets are, who actually has the key, like what person, like where are they stored within the firm, etc. And I mean, these are like super important questions, because I mean, if you come in as a liquidator, and when these liquidators don't really have experience in liquidating crypto companies, and especially not like staking or whatever, I mean, they have no idea what to do, and they have no idea where to look, right? So from a practical perspective, there are lots of other questions that are super relevant. And FINMA, for example, mentioned this so-called digital asset resolution package. It's kind of we always call it a last will For a crypto company, it's kind of a document you need to have in place that kind of outlines, okay, where are my assets, like who has access to them, like, kind of just a comprehensive list that if somebody from the outside comes in, actually has the chance to, do a liquidation the way it is supposed to do from a legal perspective, right? Just kind of to highlight that, legal is one side, but then the practical implications, that's a whole nother story.
And this I find very interesting too, this digital resolution package coming out of the 2008 financial crisis and the requirements that were put in for systematically important financial institutions, and the idea being that, okay, digital financial institutions could play a similar role. We need to know where the private keys are, right? We need to know how we actually get to these assets and unwind these transactions in the case of a major insolvency. And from my own personal experience, I look at the ongoing process with FTX in the US, and it's been quite lengthy to actually find where this stuff is. Even a year later, they're still discovering new wallets that nobody knew was out there. Oh, here's a few $100 million worth of assets that somebody squirreled away, right? There's no records, no plan, nobody knows where anything is, and that's clearly what the regulator wants to avoid in an insolvency situation.
Chris, there's also another case, the Coinbase hearing. Can you share any more information about the Coinbase case?
Yeah, sure. I think this is probably one of the other big interesting. There's a lot of interesting cases in the U.S. right now. I would take a step back and say that contrary to the approach in the EU and Switzerland, which has generally been more regulatory clarity and actual work to try to set the framework for this new financial infrastructure, the U.S. sadly has not really taken this approach, and the only clarity that's really coming out is through the various court cases that have been working their way through the system over the last couple of years: Ripple, Terraform, Coinbase, and Kraken, if you're talking about staking. And so when you're looking at what is the current state of play, what is the current best practice, you're really looking at court cases and saying, okay, what led the SEC to file a complaint? What things were they focused on? Coinbase is particularly interesting because there were 5 main claims brought against Coinbase: unregistered exchange, unregistered broker-dealer, etc., and then a 5th one for staking as essentially the offering of an unregistered security, i.e. an investment contract in SEC parlance. And the first oral hearings in this case took place on the 17th of January, and the feedback from the judge was quite interesting. The judge was quite skeptical of the staking claim, the SEC's claim that a staking as a service offering from Coinbase would constitute an investment contract. The judge seemed more to take the view to say, look, this seems like just sort of earning interest on a bank account. It doesn't really seem to be an investment contract. And there was some discussion around the various aspects of the Howey case, saying, okay, is this really ministerial efforts or managerial efforts? Is there a genuine risk of loss that's being put on the customer here, etc.? Now, the oral arguments, very tough to take away any sort of meaningful legal guidance from that. At the end of the day, it's not a written court decision. It's the judge testing out different legal theories with the participants. But if you look at these tea leaves, they seem to suggest that the judge was skeptical of the argument that something like basic staking as a service would be considered an investment contract. This is interesting to compare to the case in Kraken, which looked a lot more like an investment contract, i.e. you give us your tokens, we offer you a fixed rate of return in exchange for staking those tokens. We don't pass along the underlying rate of return. In Coinbase, what you see is what companies typically offer now. You can stake your tokens with us, we provide the technical infrastructure, and we take a skim off the rewards as the fee for operating that infrastructure.
That's great. Thank you so much. Go ahead, Romina.
Yeah, I think the discussion in the US was already quite sophisticated or very detailed. I think it was great that it also challenged a bit the Howey test, and if it's still, living up to our current technical world, or if we have to, how are securities classified today, right? And we have the US logic, and then in Europe or in other jurisdictions, an investment or a security is defined very differently. But I think one important point when it comes to the ministerial versus managerial activity, and do we have investment return here? What are those staking rewards? I think a fundamental point is that those returns, they can't be predicted. There is not like a clear linear relationship or computation behind it, but there is also a coincidental nature about which validator gets which block to validate and how high the rewards are. So this is also, I think, very much different from how in many jurisdictions investment or financial returns are defined as an additional level beyond the Howey test. And I think this will also be very important across all those different jurisdictions when trying to find a consensus about what staking is.
Yeah, and I think if I may chip in there, I think actually it's super interesting to hear what you're saying, Chris, to see kind of how the US is really focused on the question, whether this is an investment activity or not. Whereas, the stuff we just talked about before in Switzerland, it was mainly about, okay, like what's the custodial nature and the custodial element there. And the whole question around whether staking is kind of a passive investment or not, or in some kind of investment, capital market instrument, whatever, it's really kind of not, it's not really talked about much, in the sense that it's quite clear that it's not, right? I mean, we always like to say that staking, we think of staking as an active service to the network, which you are being rewarded for. Like you can be rewarded for any kind of service, right? And which is fundamentally different than a passive investment you would have in another capital market instrument like a share or a bond or whatever, right? So where you just passively invest, and the other is kind of where you actively do something and you actively provide a service. And this seems to be quite, if you can say the consensus here, that that is the case, and that staking is not an investment activity. So it's actually, yeah, it's interesting to see how the discussion is really, around the different topics still.
Yeah, I agree with that completely. And if you go and read the filings in the Coinbase case, the arguments from the SEC and the arguments from Wachtell and Sullivan and Cromwell, why the SEC is wrong. I mean, you really see this is a fundamental difference of approach, I think, between the jurisdictions in Europe and the United States, because the arguments in Coinbase are essentially, does this look like an orange grove? Does this look like an investment of whiskey that generates returns? Does this look like other products that the SEC has deemed an investment contract over the last 70 years? And how do we apply Howey to this new set of facts, where the discussion in Europe at this point in time is very, very different. I would say much more productive actually in Europe. I tend to have perhaps a bias on my side, but a view that innovation is easier in the US. But in this regard, I would say quite the opposite. In fact, it is much easier at this point in time to innovate and operate in Europe without the fear of a very, very harsh punitive result from the regulator. I mean, we tend to operate, we want to do the right thing with the regulator, but we also believe that the regulator will work with us if it feels like we're doing something wrong. Whereas in the US for the last couple of years, I don't think you have a lot of comfort that the regulator will work with you in a productive way, unless work with you means bring you to court, right? That seems to be the primary means of engaging to shape the market.
But then I also saw in some European jurisdictions, for example, that they would consider staking a lending activity, or some didn't make expressions on that. So I'm also quite excited about the dialogue then, or the general conversations on the European level, and how this can be embraced by MiCA in the future. But I guess that will be a longer time. So until MiCA is fully, or like an updated version on MiCA gets implemented, we will basically also have to work with the definitions on the national level. And they can be still quite different. But the good thing is, if we have like crypto asset service providers and so on, at least like we have like this harmonized environment. Yeah.
For lending, I assume you mean Germany and similar countries, or did you have something else in mind?
Yeah, I actually saw it when I did some research for France, but was also not a public statement from the regulator, right? And also that is one of the points. There are not many regulators yet that have made statements on liquid staking. So we basically work with assumptions and play by ear from the lawyers or the counterparties that are in the conversations with the regulators and heard something. But it's still a bit tapping in the dark. And we have to have individual conversations.
I hope we're definitely doing our best to actually bring as much clarity in the room as well, speaking directly to the regulators and not just hearsay. We did get a question from the audience that kind of taps into that particular sector. So a person is asking whether you see that staking might get a complete new set of regulations. Would that be a bespoke regime, let's say, or do you believe that it's better to actually just adapt, for example, what we already have?
Is this in the U.S. or in a European context? I mean, my view is that in the U.S. you're most likely to see FinCEN deal with staking and some sort of updated documentation, and tax authorities in all sorts of jurisdictions have started to engage very actively, I think, with staking to say, how should these rewards be treated? Are they ordinary income? Are they capital gains of some sort? Are they subject to VAT? Right, to answer these sorts of questions. I suspect that in the EU, the last sort of EU-related matters I've seen on this was at a conference in Brussels not too long ago, and I think that at the EU level they're very aware of staking and DeFi generally, and I would expect to see new regulations targeted to those areas at some point in the not too distant future, because I don't think those areas were particularly well covered by MiCA. You can see them start to be picked up in some of the new AML and tax regulation, DAC 8, for example. But I don't think they will live in the shadows forever. They know they're out there and they'll need to be covered at some point.
Yeah. So from my experience, I also saw the different legal experts in various European jurisdictions to rather find like the analogy how this applies to MiCA. So we already have a new regulatory framework that is not the securities framework. So I don't expect that it will be something completely new. And next to the MiCA, where we have like the definition on what a token, how it would classify, if it's a simple crypto asset or if it has other financial market or product features. For the staking in Europe, general roles around staking or liquid staking, we also have the role of the technical service provider. And they are often like an outsourcing partner. And for example, speaking for Germany, they are not subject to all the, for example, KYC and AML duties, but they are integrated in the reporting line to certain aspects, or there have to be certain duties when onboarding partnerships. So I think like this is what I would be very interested on, how the European regulators or also the national ones, how they would see like those staking like service providers and also institutions that engage in direct staking, where they see the technical service as it has already been defined in the existing frameworks.
I think in that regard, two areas seem of interest to me. It's mainly the ability, I've seen this in Switzerland, and I think also the EBA, the ability of regulators to look through parties into their technical service providers to some degree, right? So this is something we've talked with our Swiss counterparts about a lot. They want to make sure that the regulator, if the regulator knocks on the door, the regulator can come and look at the technical service provider. But then from our standpoint, we say, okay, great, we're a technical service provider then, right? The licensed entity is somebody who's sitting upstream from us, who then needs perhaps to look into our technology. But I agree with you, Romina, that the structuring seems to be okay. We are not the one who's providing the licensed activity at this point in time, right? That what we're providing is really a technology backend to enable other front-end integrators or customers to provide something to their customers. But we are not falling into the same buckets necessarily that they would.
And connecting to this, I think from what will also be quite interesting, or what's not really clear yet, when we speak about decentralized concepts of staking, let's say DVT technology, right, where you don't directly operate a node individually as a service provider or a financial institute, but you just participate in a DVT, or also open source middleware such as Lido, which is also developed by a DAO, right, where there's no direct centralized counterparty. Like, how do we work with DAOs or this whole decentralized concept when identifying, is this a technical service? How much is the technical service also connected to the identification of the service provider? So this is also what frequently causes questions marks in MiCA, where we also don't have this term of what is decentralized or the issuer term fully defined yet.
Yeah, very much reminds me of the recital that excludes the fully decentralized protocols, right? And now everybody's still talking about, well, what does that actually mean? And to which extent do we exclude them from the application of MiCA? I think those are definitely going to be questions that we are going to address with all the local and the international regulators. We did receive a few more questions, so if we can take a bit more time to address those. To a certain extent, I think some have already been addressed. So one question was, how far are we for courts to start to make decisions regarding different staking? I think to some extent we've actually answered that. And then the other part of that question is, who should be the proposer of the questions or the laws? So maybe this is an interesting one. Should it always be the regulators? Should it always be the member states? Is the industry also sort of integrated in these processes? Is there somebody else that also proposes, drafts the laws?
Yeah, maybe I can give some insights on how it happened in the recent FINMA case. And I mean, it's obviously not the same in the EU, and Switzerland is much smaller, and I think it's much easier there to have a direct conversation with the regulator. But nonetheless, I think, I mean, the way that FINMA approaches these crypto topics is that they do issue guidelines. I mean, I think back in 2018 and 2019, they issued their first guidelines on ICOs, on token classification, stablecoins, and all of that. And then what they also regularly do is they kind of hold so-called round tables where they, invite market participants, they invite all the crypto, foundations, associations in Switzerland, law firms, etc. And then they kind of inform on new trends in regulation, right? And like kind of what their main focus is right now, how they intend to apply the laws to different, products and whatnot, right? And so this is also what happened in the staking case. So last summer, FINMA held such a round table where they informed on staking, or informed on staking. It was just a very general statement that, hey, guys, I mean, we're looking at this. Right now, we think that staking may usually require a banking license. And this was kind of a statement like that, right? And then this really caused an uproar in the industry in Switzerland then. And we kind of got together and then formed, opinions, arguments. We wrote, articles, legal articles in journals and all of that, to kind of take a counter position to that, right? And then they opinionated and kind of elaborated counter position on that. And what happened then is, like 6 months later, they looked at that, they held another round table and were like, okay, we've seen that, we shifted our opinion, and we're kind of not going your way, but kind of finding a middle ground of, okay, we're seeing where you're coming from, and we're trying to find a solution that lets Switzerland, have its market share in staking services. And yeah, so for that, I think this is a very good example of how it can really help to engage in the conversation with the regulator. But then again, maybe I might be a bit biased, and then I'm well aware that, in other jurisdictions, the regulator doesn't have doors that are, that wide open as it is in Switzerland. But I mean, I'm happy to hear your, I know that I'm sure the experiences, and I know, I mean, because I've also, been around in other jurisdictions, and I mean the experience is probably quite a bit different elsewhere.
So well, I like that, how you called it the doors wide open at FINMA, but it seems like they have a preference to whom they want to speak, so they don't speak to all projects.
Yeah, I mean, Yeah, you're right. The roundtable is quite, it's exclusive in the sense that, it doesn't, like, not a lot of people get invited, but nonetheless, they hold such a roundtable and, like 1 day or 2 days later, everybody knows about it. But you're right.
The
On a granular
protocols
level,
also
it's
wouldn't
still,
participate, only the banks or the custodians and so on.
No, I agree. You're right. It's still granular and it's not as open as it should be. But I think, in international comparison, I think
engaged.
And in France, for example, the AMF, I think, has been fairly engaged in speaking with industry and soliciting industry feedback. I think they see themselves as the source for a lot of the legislation and definitions that made its way into MiCA. And it's the same sort of thing as Romina is describing. Yeah, you can't just show up as an individual and say, okay, here's my idea. But if you're in the industry or you're connected to somebody in the industry, the feedback loop is fairly good, I think, in terms of shaping how the regulation is going to look. And I have the feeling generally that the various European jurisdictions realize that this is a new area of regulated finance and that they are competing to some degree to see who can be friendly to welcome this business, because who's going to start delivering those first licenses under MiCA, because I think there'll be kind of a push for people to go where everyone else is, right? And they see that better to be open here than to be closed at the end of the day, because if you miss out on the gold rush, it can be hard to get yourself back into it.
Yeah, for sure. The AMF and the ACPR both have actually been quite active in France. They've also been issuing their own DeFi papers with plenty of questions. So there is an ongoing dialogue, I would say. We're also sort of actively responding to both the questions and we're engaged in creating the position papers or certain outlooks, for example, just to be communicated beforehand. It's also going to be a very important year this year. It's the elections year, basically, for half a world, not just Europe. And this means that we can also kind of have a strategy to put that on the political agenda, maybe communicate with the new MEPs, elected people, and see where they stand, open up the conversations, just kind of to bring them on board or to update them on what has happened so far, and then just about what the industry kind of envisions or what we want to put the attention towards in the future. We do have another more question, which is, what do you think about payment branch? Will the technical evolution of the DLTs under MiCA regulation and the change from proof of work to proof of stake in Ethereum influence the use of tokens for payment, as in versus the fiat money, on national and transnational cross-border? Any opinions on that?
I think it's an interesting question. It depends a bit on the context. I mean, if I look in the US, it's very painful to make bank transfers, and so solutions are very readily accepted by the market to try to solve this problem. If I look in the EU, it's become increasingly easy to make bank transfers. I can make instant transfers cross-border within Germany. They happen in seconds. I think there'll be some growth here for the use of tokens as payment use, but I don't think it's going to be the exclusive form of payments. It's a very interesting question. To what extent do these payment rails over crypto actually get integrated into the financial system, and where do they make sense? Do they make more sense settling, for instance, trades or currency exchanges between large market participants as opposed to settling individual payments at the retail level? I think that depends on how the technology grows.
Yeah, maybe just one thought on that as well. I mean, in relation to stable coins, right? I think, a large part of MiCA is concerning stable coins. And so there's a lot more regulation on that end coming. And I think, from our experience in practice, we've set up multiple stablecoin protocols or projects in Switzerland. And up until now, it was that kind of relatively easily done, fairly speaking, right? You kind of had your regulation in Switzerland, which is quite comprehensive around stable coins. And then in the EU, it was a bit unclear. But now with MiCA coming, it's really difficult to figure out the best approach on how to bring a stable coin to market now under MiCA. even the first question in figuring out, okay, where do I apply for a license, and like what's the way to go, right? Like what jurisdiction do I pick? Kind of jurisdiction shopping around in MiCA, how is it possible or not? I mean, things like that, they get a lot more complicated now also with regards to stable coins. So yeah, I mean, I'm not sure kind of what the future for that looks like, but it's for sure going to be not much more difficult now to kind of get a stable coin up and running under MiCA, I think.
Yeah, we're still in the middle of having these conversations, especially with the European Banking Authority. There has been just today, actually, one of the public hearings. I'm glad that we at least have those, because it's still not everything is being set in stone, right? So we have level 1, MiCA, and for stablecoins, it's going to become applicable in June, I think the end of June. So everybody's now asking, how is this going to play out in practice? And luckily, we have the public hearings. There is a bunch of consultation papers being issued, and we're going to respond to the third batch. There's also a fourth batch that we are also preparing. That is, I think, the submission is due in March. But yeah, a lot of questions are still not fully answered. But at least we now have the public consultations. We're able to participate also virtually, and they're luckily open to discussion. So it's been quite a lot of back and forth communication in that regard. Hopefully, it's going to result in having more clarity and stablecoin issuers knowing exactly how they have to report and what types of reserves they have to have, or what is going to happen with liquidity stress testing, etc. Very, very cool. We have one more question, and then I'll give it for the final round of feedback and conversation. So also, do you have any thoughts on DeFi staking, particularly projects like yield tokenization, maybe as in a Spandel Finance? And could we consider that these tokens are derivative products or not?
Yeah, I mean, I would take this just on the mere analogy to liquid staking. And I think from how like derivatives is defined in a bunch of jurisdictions I came across was that there has to be like a direct programmatic or computational relation between the value of the underlying and the value of the newly created derivatives. So there has to be a direct relationship. And if that is happening, like with a DeFi token, what was it, Pendle Finance, what did they do? You just mentioned it was restaking or also staking DeFi tokens, basically. That yield, I mean, it's really on a case-by-case basis, exactly how we see it with liquid staking. I think it doesn't make sense to give like a too general statement on this, but derivatives has usually a very clear definition. And I think most liquid staking tokens, for example, don't directly qualify for, but they would if there would be a set one-to-one relationship, right, between the underlying value that is staked or not. But that depends.
Yeah, I would feel the same way. Could be, could not be. It depends very much on the structure of the token itself and how it relates to the underlying assets. And I think also it's also kind of a pure jurisdictional question as well, right? I mean, is this a derivative product for purposes of the CFTC in the US? Is this a derivative product for purposes of, MiFID or other regulations in Europe? I mean, they're quite technical questions to answer at the end of the day, and very hard to answer in the abstract.
Yeah, absolutely. And I think when you talk about, when you bring in the term decentralization there, I mean, you open the box of Pandora anyways, and the whole question around, I mean, that we just discussed before on, the issue that we're still missing a uniform definition of what decentralization means. And I mean, quite interested in that because it's also something we do a lot at the DeFi Collective, that we're concerned about that. But I mean, this is, I think goes beyond, the question, is it a derivative or not, whatever, just kind of the general missing understanding of decentralization is an issue that will need to be solved sooner or later.
Absolutely. There seem to be a lot of things, a lot of work that awaits for us in 2024. I have just one last question for you, and that is if there is any positive predictions or any crypto trends that you would like to or that you anticipate in 2024.
I think I would love to see a European-based staked ETH ETP and products like this, because I think here there's still a lot of potential to innovate within the existing capital market framework. But I'm also very much excited about other staking innovations, such as restaking, and how they will play a role in a few years' time.
Absolutely.
Yeah, I don't know. I'm not very good at predictions, but I mean, aside from the market, sticking to kind of the legal nature of this session here, I think what we've been talking about, the regulation, I think it's a trend that will continue in 2024 for sure and beyond. I mean, we talked about it, right? MiCA is coming into force. Other jurisdictions are starting to act more. In Switzerland, there are whispers around, do we want to implement the DLT law 2.0, which is modeled after MiCA? So, I mean, there's a lot going on, and I think this will continue to intensify. Yeah.
Amazing. Chris?
Yeah, from a legal perspective, what I think is going to continue to be a question, and you can see there was just a series of ESMA consultation papers released, I think yesterday or maybe 2 days ago, and one of the main questions, they talked about reverse solicitation. Okay, this is kind of a financial instruments question, but then also the question of how does one classify crypto assets as financial instruments? Because I see here that there's still a gap in the regulatory world between the MiFID financial instruments, financial products regime that tends to sit on traditional financial players, London Stock Exchange, SIX Digital Exchange, and this new area of crypto asset regulation. And these two worlds want to come together in some way, but it's not entirely clear how you pull it off quite yet. And I'm hopeful that at least on the European side, you see progress on trying to answer that question. Maybe difficult progress, halting progress, but progress nonetheless in bringing those two worlds a bit closer together.
Absolutely. Just read the one on the reverse solicitation yesterday, and it seems to be a very exciting one. I thank you all for taking the time. I know it's kind of getting late, but really just very insightful. Thank you for fighting the battle and for actually bringing all the knowledge, all the information, both to the regulators and to the industry, and especially to our LinkedIn Live. So thank you, and I hope that we'll meet again and that we'll have plenty of time to actually discuss all the regulatory challenges in the future as well. Thank you also for the questions from the audience. I hope you enjoyed this session. If there is anything else that you would like to comment on, feel free to do it on LinkedIn. I think we tagged all the names, so you'll be able to answer all the questions in the future as well. Otherwise, check our website, eu.ci, or subscribe to our newsletter. We're going to be publishing more updates on LinkedIn, both on Twitter, and share all the regulatory updates with you over the event. Thank you so much for today.
Thank you. It was a pleasure.